Hello everyone, my name is Elizaveta Gnatishina and I'm a first-year student of master degree, which is called European Legal Studies in University of Turin. In today's worldwide situation caused by COVID-19, we're faced with a bunch of new methods of teaching, and this is the main reason why I'm here. I have prepared a brief speech and would like to tell you about a course which I have started to learn, called Transitional Justice. Transitional justice is an approach to systematic or massive violations of human rights that both provides redress for victims and creates or enhances opportunities for the transformation of the political system, conflicts, and other conditions that may have been at the root of the abuses. A transitional justice approach thus recognizes that there are two goals in dealing with the legacy of systematic or massive abuse. The first is to gain some level of justice for victims. The second is to reinforce the possibilities for peace, democracy, and reconciliation. To achieve these two ends, transitional justice measures often combine elements of criminal, restorative, and social justice. Transitional justice is not a special form of justice. It is rather justice adapted to the often unique conditions of societies undergoing transformation away from a time when human rights abuse may have been a normal state of affairs. In some cases, this transformation will happen suddenly and have obvious and profound consequences. In others, they may take place over many decades. The United Nations has defined transitional justice as a full range of processes and mechanisms associated with a society's attempt to come to terms with the legacy of large-scale past abuses, in order to ensure accountability, serve justice, and achieve reconciliation. Moreover, we have to bear in mind that the United Nations rule of law and transitional justice activities include developing standards and best practices, assisting in the design and implementation of transitional justice mechanism, providing technical, material, and financial support, and promoting the inclusion of human rights and transitional justice considerations in the peace agreements. Talking about aims of transitional justice, we have to understand that these ones will vary depending on the context, but these features are constant. The first one is the recognition of the dignity of individuals. Second one is the redress and acknowledgement of violations. And the third one is the aim to prevent them from happening again. Transitional justice consists of both judicial and non-judicial processes and mechanisms. The first one is prosecution initiatives. Prosecution initiatives aim to ensure that those responsible for committing crimes, including serious violations of international humanitarian law and gross violations of international human rights law, are tried in accordance with the international standards of fair trial and, where appropriate, punished. States have the primary responsibility to exercise jurisdiction over these crimes. Therefore, in relation to alleged crimes committed in the context of the conflict or repressive rule, transitional justice programs will seek to reinforce or develop national investigative and independent and effective judiciary, adequate legal defense, witness and victims protection and support, and human characterization facilities. Second one is facilitating initiatives in respect of the right to truth. Truth-seeking processes assist post-conflict and transitional societies investigate past human rights violations and are undertaken by truth commissions, commissions of inquiry, or other fact-finding missions. The right of individuals to know the truth is supported by several treaty bodies, regional courts, and international tribunals. Truth commissions are non-judicial or quasi-judicial investigative bodies which map patterns of past violence and unearth the causes and consequences of these destructive events. The third one is delivering reparations. Reparations programs seek to redress systematic violations of human rights by providing a range of material and symbolic benefits to victims. Reparations can include monetary compensation, medical and psychological services, health care, educational support, return of property or compensation for loss thereof, but also official public apologies, built-in museums and memorials, and establishing days of commemorations. The next one is institutional reforms. Public institutions that help perpetuate conflict or repressive rule must be transformed into institutions that sustain peace, protect human rights, and foster a culture of respect for the rule of law. By reforming of building fair and efficient public institutions, institutional reforms enables post-conflict and transitional governments to prevent the recurrence of future human rights violations. And the last one is national consultations. National consultations are a critical element of human right-based approach to transitional justice, founded on the principle that successful transitional justice programs necessitate meaningful public participation, including the different voices of men and women. Public participation reveals the needs of communities affected by conflict or repressive rule, allowing states to craft an appropriate context-specific transitional justice program. Whatever combination is chosen must be in conformity with international legal standards and obligations. Many of these mechanisms are established with a specific mandate and time frame. Nevertheless, experience shows that temporary and permanent mechanisms can coexist in an effort to deal with the legacy of abuse and with prevention. Such mechanisms can be international, regional, or domestic. For example, an Inter-American Court of Human Rights and some constitutional courts have provided important contributions to transitional justice. Transitional justice is built on the assumption that social, economic, and political changes are possible when significant negotiations of power are taking place in a state. Nevertheless, transitional justice emerged to deal only with a limited dimension of those changes, the legacy of large scale, and preventing their reoccurrence. While human rights law has strongly influenced transitional justice, the latter has focused on violations of civil and political rights. Transitional justice has therefore evolved in relative isolation from important developments in economic, social, and cultural rights. Transitional justice mechanisms may lack economic and human resources and/or moral and political capital. However, experience has shown that even though they face complex challenges, they are necessary and could have a lasting impact on a society. For example, through the official recognition of past violations and by empowering victims. Their contributions to social change may be modest but is important. Taking into consideration the limitations of transitional justice mechanisms, it is essential not to raise unrealistic expectations. This is particularly true when considering the potential of transitional justice to address violations of economic, social, and cultural rights. Although these rights may be included in transitional justice process, even a successful transitional justice experiments will not secure the enjoyment of these rights by everyone. Nevertheless, transitional justice can contribute to the fight against impunity for violations of economic, social, and cultural rights and to their prevention by laying the foundations for forward-looking reforms and agendas. Transitional justice emerged as a part of recognition that dealing with the systematic or massive abuses requires a distinctive approach that is both backward and forward-looking. Transitional justice measures aim not only to dignity victims, but also to help prevent similar victimhood in the future. The long-term goals of transitional justice measures are to promote peace, democracy, and reconciliation, with the idea that these conditions help to prevent the systematic or massive violation of human rights. Where are we now? Best understood, the practice of transitional justice today is the attempt to confront impunity, seek effective redress, and prevent recurrence, not in the routine application or normative standards, but in the careful and conscious appreciation of the context where it is to be done. My part is over. Thank you for your time and goodbye.